Can you briefly explain in plain language what the recent Texas federal court ruling actually changed regarding silencers, short-barreled rifles, and short-barreled shotguns under the National Firearms Act?
In a brief answer, the new ruling has removed silencers from the NFA list. Form 4 registry is no more for those individuals named in the lawsuit, primarily customers that are part of Silencer Shop or Guns of America. In a nutshell, that's essentially what it's done. Is the judge has made the ruling unconstitutional.
How does the fact that Congress reduced the NFA, making transfer tax to $0 factor into the judge's decision?
From what I know, having the tax amount go to $0 without getting into the judge's particular ruling is that having it $0 and a registry, those two items don't coincide. You can't have a zero tax amount and a registry. So it has nothing to do with the 2A or the Second Amendment. This is strictly a constitutional matter, and the judge found that having a $0 amount and a registry was not constitutional.
Does this ruling apply nationwide right now, or is it limited in some way, for example, to the specific parties in the lawsuit or their customers?
It is nationwide, but with some caveats. Depending on the state's individual rulings and their state laws, if a state has NFA restrictions, those states still have to adhere to the Form 4 process. I believe there is something around 42 or 43 states that do get to participate in silencer shops plaintiff standing. Idaho being primarily most important to us here at Independence. We do not have NFA restrictions, so we adhere to the silencer shop side of the case. So all of our customers that have been customers with Silencer Shop or are members of Guns of America can take advantage of the suppressor transfer without a Form 4.
What has Independence Indoor Shooting observed so far in terms of customer questions or interest in these items since the ruling took effect?
Excitement. Customers are having a lot of questions if they can come in and buy and transfer right away. It's still soaking in, I think, in the environment around the valley here. There's still a lot of apprehension, I think, people wanting to see how this plays out. But right now there's a lot of excitement, a lot of questions.
Even if federal registration requirements are effective for certain parties, what role do Idaho state laws still play in the possession, transfer, or use of silencers, SBRs, or SBSs?
Customers can come in right now and purchase a suppressor that has been transferred to our FFL from Silencer Shop. The ruling doesn't cover our entire inventory. It's only items that have been transferred from Silencer Shop. Now, Guns of America members can take advantage of any suppressor in our inventory and have that transferred. These would be transferred on a 4473, NICS background check done, and then the suppressor would go home. As far as SBRs, SBSs, those still have to have a Form 4 done at this time because those are part of the Gun Control Act and those require the Attorney General to make a ruling on that, and that has not occurred as of today. But all Class 3 machine guns, explosives, etc., still require Form 4 and approval.
Machine guns and destructive devices were not treated the same way in the tax change or the ruling. Can you clarify what remains fully regulated under the NFA?
As far as I know, it's everything outside of suppressors are fully regulated as far as Idaho is concerned. The only thing that we can transfer at this time without a Form 4 is the suppressor. I don't know all the details as far as the classifications of everything else and how that's going to happen. A lot of that information is still coming out, whether it's from a 2A attorney or from the ATF. The DOJ hasn't officially made a hard ruling. They've come out and said that they're still examining the federal judge's ruling. But as far as moving forward, the ATF and the DOJ have 60 days still to make a final call on this.
What practical advice would you give customers who are considering purchasing a suppressor or a short-barreled firearm right now while the legal situation is still developing and a possible appeal remains open?
I would recommend that they take advantage of it. I agree that it's an unconstitutional decision. The state of Idaho and the lawsuit put forward by Silencer Shop has allowed this to take place. This FFL is completely behind that decision. But as far as SBRs and SBSs, those items, just to be clear, still require the Form 4. But if I was a customer, I would be taking advantage of the situation.
How important is it for the buyers to confirm the current status of any item, registration, paperwork, background checks, directly with the dealer, and to keep records given that the landscape can shift?
I think it's always important for customers to stay up on these things. I would be careful this is going on the internet. I would be careful always and double check the information that you get off the internet. I do compliance here. I stay on top of what the ATF and Silencer Shop and other entities are putting out. Right now, we're getting all of our information strictly from either the ATF or Silencer Shop. So with Silencer Shop being the primary plaintiff in this case, we're kind of following suit with them and how things are going. But as far as customers, I would say customers need to do their due diligence and be careful who they get their information from. Make sure that they're following the laws of the state that they live in, and just educate themselves as best they can.
Are there common misconceptions you're hearing from customers about what this ruling does or does not allow, and how do you help clarify those?
As of today, I haven't heard of a lot of misconceptions. Customers are very open and asking questions. I haven't had any customers that have come in the store and have pressed a different viewpoint. They're being very inquisitive right now, which I think is good. I think the customer base here takes their time to educate themselves and ask questions.
For someone who already owns a registered NFA item, does this ruling change anything about how they must store, transport, or document that item?
I don't know for sure. I don't believe so. I think that if you've already got a Form 4 and approval on a previous NFA item, I would still move forward as if that still applies to that item. Until there's more clarification, I wouldn't do anything differently with a pre-approved or an already approved NFA item.
What resources or next steps do you recommend customers use to stay informed as the Department of Justice decides whether to appeal and as any further court actions unfold?
I would stay on top of Silencer Shop. Their legal team are putting out statements. I would stay up to date with their statements. I would also watch ATF and DOJ statements that they put out. I would always recommend talking to a 2A attorney, and be careful of getting advice as far as hard answers on information that has still been unproven. But Silencer Shop is probably the one I would follow most closely since they're the lead plaintiff.